As God pleases, Honorable Chairperson, members of the panel, good morning to the members of the panel that we didn't get an opportunity to see this morning. I appear for the applicants stroke appellants in this matter with my learned friend Ms. May, and also I have a pupil member, Ms. Litwaba, who unfortunately doesn't have yet the right of appearance, but we discussed that with the presiding judge. As the court pleases.
Thank you, Mr. Mpofu.
May it please you, my lord, and my ladies, and the professors on the panel. I appear on behalf of the first respondent, together with Mr. Mitchell.
Thank you, Mr. Toby and Mr. Mitchell. All right, first of all, we just wish to apologize for starting late. Unfortunately, there was a problem with some logistical arrangement. As you could see, there was going to and fro. Yes, so, but we should have started at 9:45, but due to the logistical arrangement, then we started late. And I hate to start late, so unfortunately, it's something that was beyond our control.
Yes.
With me, I'm having as Justice Modiba on my right, and on my left is Justice Yakub, and on my right is Professor Angelo Makanya, on my left is Professor Puku. Thank you. As I indicated to you in my chambers, I'll give each of you 10 minutes time during which you'll be able to present your case without any interruption. But after the end of 10 minutes, you must expect some questions from the members of the panel. So that's number two. Number three, in terms of time, we agreed that we'll give Mr. Mpofu 1 hour, 15 minutes. And Mr. Whitehome 1 hour, and then Mr. Mpofu will have 15 minutes on reply.
That's good.
That arrangement still stands.
Indeed, ma'am.
Okay. Is there anything that you want us to start with before we start?
Yes, my lord. Just in terms of the just logistics.
Yes.
Indeed, your lordship indicated some of the logistical problems, so the late start is not an issue from our side. The other issue that the presiding officer indicated was the issue of the bundles, the pleadings bundles.
Yes.
Our attorneys are attending, our respective attorneys are attending to securing those bundles, and we hope that they'll be here on time. It's quite a lot of photocopying.
Sure. Fair enough.
Thank you.
And then the authorities bundle as well, if possible.
Yes. Also, all right. The other side's authorities bundle is also being printed. Ours is, I beg leave to hand up.
Yes. Sure.
Yes. And ours is relatively shorter because we didn't repeat some of the authorities that they had put in their bundle. But at least for the purposes of my argument, it will assist as court please.
I think that in the meantime we can proceed with. We'll use the electronic version of the pleadings, because unfortunately.
Yes. What we will
do could not be able to send everything.
Yes. What I will do, or at least what I think both of us will endeavor to do, when we refer, for example, to the affidavits, we'll just refer to the paragraph numbers of the affidavits to make it easier, because it's not in front of you.
Okay. Just give me a second. I just want to open my pleadings file. Okay, you may start.
Yes, there's an additional case which came loose. I forgot. put it at the end of our bundle.
You can start, Mr. Boko.
Right. Thank you very much, Justice Zondi. The other housekeeping matter is that I will deal with. You would have noticed from our heads that we've reduced the issues somewhat. In fact, we've reduced them even further now.
Yes.
In reality, one can say that there are 4 issues.
Okay, because previously you had reduced them from
to 5, from 7 to 5.
From 7 to 5.
Yes. But the last 2 really are one issue. That's the point I seek to make. The last 2 issues of those 5 really deal with the issue of sentence. So the 4 issues are broadly as follows. It's the issue of bias, the issue of ultra-virus. I'm just using like broad headings here. The issue of the conviction for an offense.
That be section 47 argument.
47, yes. And then the last issue is the sentence. In fact, I'll deal with sentence before conviction, and I'll explain why. Yeah. But the point I wanted to make that the issue of bias, my learned friend Ms. May will address the issue of bias, and then I'll address the rest of those issues. Those issues in reality all fall under the interpretation of section 47, the rest of those issues. All right. Ms. May will come after I have. Right. Okay, now I'm starting.
So your 10 minutes start now, Mr. Bofu, is 10:38.
That's
so
correct.
Your 10 minutes will be over in 10:48. Okay.
Yes. Thank you.
Thanks.
Right. Well, while I have the right to speak on my own, let me just make the following opening remarks. Members of the panel, this issue, the matter really is around the gist of the matter around the interpretation of section 47(1)(e) of the Constitution. But the larger question is about the rights in section 19 of the Constitution, of the Bill of Rights specifically, and more importantly, the rights enshrined in section 19(3)(b) of the Constitution. And the sections that I'm going to deal with, whether it's the ultra-virus, the conviction, the sentence, are all around what interpretation is to be given to that section. Now, the starting point is really this, that in South Africa, and in any other country, but more particularly in South Africa, we should be extremely cautious before we can ever deny the political rights of anybody. I don't have to tell this court the reasons for that. The mere reason that we have a constitution, the mere reason that we are where we are, is because people were denied political rights. People were denied the right to vote. People were denied the right to stand for political office and to hold office. And the Constitution is itself a negation of that. So our courts have said so many times in respect to Section 19 and other rights in the Bill of Rights, whenever there is an opportunity not to infringe those rights, then the court must literally grab it. And we find disturbingly that the attitude of the Electoral Commission in this matter is exactly the opposite. The attitude has been, let's see where we can catch him. And And when we do catch him, let's make sure that he doesn't come out alive. That cannot be the attitude of a South African institution, let alone an independent institution whose job it is to ensure that all our Section 19 rights are realized. So that's the first thing. And we cannot afford as a country to disenfranchise whether it's former President Zuma, the MK party, or whatever number of people support them. They claim that it's millions of people. They may be right. We'll know by the 29th of May. But it doesn't matter. It could be 3 people. But those people cannot be disenfranchised at a whim, as it were. So we're dealing with the rights. We actually, at face value, are dealing with Section 19(3)(b). But in reality, we're actually dealing with the whole Section 19. Because we're dealing with the right to vote for those people who support this party and former President Zuma. Their right to vote would be infringed because they will not have the right to choose to be represented by the people or persons that they want. We're also dealing with the Section 19 rights of the party itself. Because the party, the court knows, it has been said so many times, until recently, political parties were the only vehicle through which we could all exercise our political rights. So that vehicle itself needs to be protected. Otherwise, there would have been no democracy here if there were no political parties. But we're also dealing with the rights of former President Zuma, which have been infringed. His rights in terms of Section 19(3)(b), which says that every citizen, those we like and those we don't like, every citizen has the right to stand for political office and, if elected, to hold political office. So there are 2 rights, 2 crucial rights embodied in 19(3)(b). The right to stand for political office, and the second one is qualified. It says, if elected, to hold political office. And there's a significance in those words, if elected, because the second right, one can say, is qualified to that extent. But the first one is absolute. So we are dealing with, as a country, we've been here before. We've been to a place where the powers that be felt that it was necessary to literally disenfranchise, again, we don't know the numbers, but probably millions of people, by banning their organizations, banning their leaders, and making sure that they don't participate in the political space. And as I say, at the risk of repetition, that our constitution is a bridge away from that culture to a South Africa where, if possible, everybody should be allowed to vote. We know the loose case that I handed up to the court is the case of August and another versus Electoral Commission and others, where again the IEC once again was told by the Constitutional Court that we cannot disenfranchise people because they, like in this matter, they said, well, we have logistical problems, we cannot enfranchise, as it were, prisoners. And in any event, they have themselves to blame for where they are. Just in the same way that they are saying now, former President Zuma has himself to blame. If he wanted to stand for office, then he should not have gotten himself into a situation where he finds himself now. It's exactly the kind of mentality that was in the case of August. And in that case, it was said very emphatically that the Electoral Commission has got no right to do what it did. That whether there were logistical problems or not, it had to enfranchise those people. And the court said the following, which was very important. The right to vote by its very nature...
Just give us a paragraph number.
Oh yes, I'm sorry, my lord. Yes, it's paragraph 16.
Yes, Professor.
So the right to vote by its very nature imposes positive obligations upon the legislature and the executive. A date for the election has to be promulgated, the secrecy of the ballot secured, and the machinery established for managing this process. For this purpose, the Constitution provides for the establishment of the commission, that's the IEC, to manage elections to ensure that they are free and fair. And I won't read the rest, but that's just the preamble. Then if you go to after that quotation, it says, this clearly imposes an affirmative obligation on the Commission to take reasonable steps to ensure that eligible voters are registered. So similarly here, the Act or the entire scheme imposes an obligation on the Commission to ensure that those who are eligible to stand for election do stand and exercise their rights. But here is the often quoted passage from this case, which really encompasses everything I'd like to say by way of introduction. Universal adult suffrage on a common voter's roll is one of the foundational values of our entire constitutional order. That's paragraph 17. Sir. The achievement of the franchise has historically been important both for the acquisition of the rights of full and effective citizenship by all South Africans, regardless of race, and for the accomplishment of an all-embracing nationhood. The universality of the franchise is important not only for nationhood and democracy. The vote of each and every citizen is a badge of dignity and personhood. Quite literally, it says that everybody counts. In a country of great disparities of wealth and power, it declares that whoever we are, whether rich or poor, exalted or disgraced, we all belong to the same democratic South African nation. That our destinies are intertwined in a single interactive polity. Rights may not be limited without justification, and legislation dealing with the franchise must be interpreted in favor of enfranchisement rather than disenfranchisement. Contained there is...
So I just want to warn you...
Yes, I am aware the 10 minutes is up.
10 minutes is up now.
Thank you,
You may start expecting questions from the
As
members.
God pleases, my Lord. I'm indebted to the court for the reminder.
Sure.
Now, the reminder came in time because, as I say, that quotation encapsulates everything I want to say in terms of setting the canvas about this case. Whether you are rich or poor, exalted by everyone or the media, or disgraced by them, we all belong to the same democratic South African nation. And we must favor enfranchisement rather than disenfranchisement, and banishment, and separating people away. And there's no better case, again, to demonstrate that than the case of August, because they were dealing with prisoners convicted and sentenced in the conventional way, just as what Mr. Zuma is being accused of. But the court said, no, despite whatever those people might have done, they might have been rapists or whatever, but you can take away their freedom of movement, but you cannot take away their right in terms of Section 19. So, against that background, I will deal very briefly with the issue of alpha virus. This is a very important issue that goes into interpretation, of course, as this case is really all about, but it also goes to some of the foundational values of our democracy. The supremacy of the Constitution and the separation of powers. It also goes to the multi-party democracy, all the values that are enshrined in Section 1 of the Constitution, as well as the right to human dignity, as was said at paragraph 17 of August, that the right to vote is a badge of dignity, particularly for those who were disenfranchised by apartheid. Now, what we're saying under this section, esteemed members of the panel, is this. Until now, and this case is important for this, until now, the question as to whether who must implement Section 47 has not been asked and has certainly not been answered. There was an assumption that the Commission is the agency or organ that must administer that. But that's how the law develops. We have assumptions until such time that the issue has been raised. And the issue we're raising is the following. There is, in terms of the rule of law, because we know ultra vires is the old Latin term for what we now call the principle of legality or rationality and so on. Sometimes it's called authority, sometimes it's called jurisdiction. It doesn't matter what the term is. But the concept is the following. And that concept was captured in the leading cases of Fetcher, pharmaceutical, and so on. That public officials...
Sorry, Mr. Pope, before you proceed, I think that we need to contextualize Section 47.
Yes,
it's in the following context.
Right.
Mr. Zuma, the former president of the Republic of South Africa, is among the list of candidates that was submitted by the MK party on the 8th of March 2024. So far, so good. And then there was an objection submitted to the IEC on the 26th, 27th of March 2024 by two people. Well, it's the second respondent and the third respondent. The third respondent has since distanced himself from the objection. So we are now remaining with the objection of Dr. Matsapula.
Correct.
And it is on the basis of that objection that the IEC made a decision. That's where we are now. Okay. Now, the question is whether or not the IEC, in relying on Section 47, was correct. So it's about the interpretation of Section 47, whether it excludes or it includes Mr. Zuma. That's the whole case. That's the whole thing, issue of this case.
No,
so it's about the interpretation of Section 47.
Yes, no, it is. Well, that part is correct. Man.
Yes.
It is about the interpretation of Section 47.
Yes.
But the point I was making, my lord, is that it's not about the what I call the merits in our heads, which is whether Mr. Zuma is excluded or included only. It's about the preliminary point that I'm raising.
Yes.
Whether, in the first place, the administration, for lack of a better word, of Section 47 lies in the hands of the IEC.
Okay.
That's
so
the issue.
We at this stage, we are at ultra vires point, right, whether or not the IEC had authority to do what it did. That's whole thing about. That's whole debate about jurisdiction, ultra vires authority. Yes. So that's where we are now in relation to Section 47.
Absolutely.
Okay.
Yes, and that's why I said.
Now, your argument is the following: IEC does not have authority. That authority belongs to the National Assembly or Parliament.
Yes.
Is it well?
Yes.
Okay.
And
sure.
Thank you, my lord. So, my lord, and we say this for the following reasons. If you look at where Section 47 is located,
yes,
in the constitutional scheme, it's in Chapter 4. Chapter 4 of the Constitution is headed Parliament. The Parliament meaning the National Assembly and the NCOP. That's what we call Parliament in South Africa. And then the heading to Section 47 says membership. And so it deals with the membership of the National Assembly. And as if that's not enough, the section itself makes it clear what it deals with. It says, it starts by, crucially, starts by reminding us of Section 19. It says, every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly. Very important. You know, how a statute is framed, a statute is basically a way of communicating. It's a National Assembly writing us a letter as a nation. So they start by reminding us of Section 19, that every citizen, including Mr. Zuma, who is qualified to vote for the National Assembly is eligible to be a member of the Assembly. And then it says, except. Now that formulation already tells you something. We try to include everyone, and then but there are exceptions. So already that is the ethos of this, that we must not start by excluding, as the IEC seeks to do. We start by including, and then we apply the exceptions. And then this is the crucial part. It says, except, we go to E. Anyone who, after this section took effect, there's no problem with that, is convicted of an offense, that's the first thing. And, that word and is important, not or. And sentenced to more than 12 months imprisonment without the option of a fine, as the Lordship said, so far so good. Either in the Republic or outside of the Republic and so on. And then but, again, so there's another exception within the exception. But, it says, or this is what we call a proviso now. But no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time of the appeal has expired. A disqualification under this paragraph ends 5 years after the sentence is completed. Yeah. So we'll come to the bits and pieces of that section. The point we're making now is simply this. The IEC does not have, or must show this court, in terms of the factual case, the IEC must tell this court where it gets the authority to implement Section 47. And the answer is nowhere. And the quotation I put there from Baxter is very important. You don't say when you apply the rule of law, well, we can do everything that we are not prohibited from doing. No, it doesn't work like that. It says we can only do those things that were authorized by law to do. So if you are doing something as a public official, if someone wakes you up and says, where did you get the authority for this? You must be able to wake up and say, section this and section that and section that. And then we'll leave you alone. But if you are unable to point to any authority that empowers you to do something, then it's ipso facto ultra vires. Now, so the only authority, the only power of the IEC, my Lord, is found in Section 190 of the Constitution. So it cannot do anything outside of that. It's a creature of statute. You can't just wake up and do what you want. So, and 190 says the Electoral Commission must manage elections. I'll use shorthand to save time. Manage elections, we all know that. Ensure that those elections are free and fair, we all know that. Declare the results of those elections, we all know that. And that's it. And then it says at 92, which is the catch-all phrase, which maybe they will rely on. The Electoral Commission has the additional powers and functions prescribed by national legislation. So in other words, the IEC only has the powers prescribed in Section 190, they will manage elections and so on and so on, or they would get those powers from legislation. Now let's go to the applicable legislation. I'm sorry.
I'm sorry, but before we go to the applicable legislation, when we're interpreting or giving content to the powers of the IEC in the context of elections for the National Assembly, do we not also have to look for interpretation purposes at section 47(2)?
Yes, we will come to that.
You're getting there?
Yes, we definitely will come to that. But you see, it's said in when the Constitution, my lady, disenfranchises somebody, it will not do it by silence. I can assure you. That's what he said in August.
But
it will.
Sorry.
I'm sorry.
I just wanted to finish because my question had two parts, and it's fair to put the whole thing because you probably do the whole thing.
Yes, ma'am.
And it relates almost directly to disenfranchisement, because if you say, if this court, for example, were to find that the power lies not with the IEC but with the National Assembly to exclude a person in terms of 47(1)(e), is that not then a sort of disenfranchisement by stealth? Because then the person, as a voter, I think, oh, my person is a candidate, that means my person qualifies because the decision has been made to allow my person to be a candidate, and then I vote for that person. And then the National Assembly says, no, in terms of section 47(1)(e), you are disqualified. So then I voted for this person, but my vote doesn't count because now after the fact, the National Assembly is disqualifying me.
That is exactly what happens every day. That's what should happen. Let me explain.
Should happen.
Yes, that's what should happen.
Okay.
Because the National Assembly is entrusted with the power to manage its own affairs in terms of section 57 of the Constitution, right? One of its affairs is to determine who is a member and who is not a member. And that power is, by separation of powers, circumscribed to the National Assembly. The judiciary cannot get into it, the executive cannot get into it, right? Let alone the IEC, some independent institution, which is not even one of those. It is put into the four corners of section 57 of the Constitution as a function of the National Assembly. Now let's come to your specific example. That, what you've just described is actually what happens in practice. Because I vote for what your ladyship calls my person. If I vote for, if the IEC allows my person to be on the list now, right? That was on the 28th of March. And then in April, that person is sentenced to 10 years. What has happened? The IEC has got nothing to do with it. The National Assembly will deal with that issue because the person was sentenced, let's say, on the 5th of May. On the 29th of May, when the people are being sworn in managing its affairs, the National Assembly will then say, no, Mr. My person, you are not eligible to be a member of the National Assembly. But it's even worse, my lady. Forget about elections. In 2028, my person gets sentenced to 20 years. The National Assembly, not the IEC, will then say, Mr. Person, you've now been sentenced last week, you can no longer be a member, and so on and so on. Right until the end of it, the IEC does not enter anywhere in this. Right. So, that's the whole issue. Section 57 must be given content. And also Section 48 of the Constitution. Section 48 of the Constitution says that members in reality become members once they are sworn in. Right? Just like we all become whatever we are once we're sworn in. Cabinet Minister, President, whatever. So, the reality, that's why the Americans came with this concept of what they call a president-elect. So until you have been sworn in, you are a president-elect or you are an MP-elect, if you like. Right? You are not a president, or you are not a member of the National Assembly, per se. You've just a person who has been voted in. That is why Rule 13 of the Rules of the National Assembly says that at its first sitting, and you'll find that expression in so many places in the Constitution, the first sitting of the National Assembly is the one that is regulated. Why is it regulated? Because it's the special place where all these questions are dealt with. That meeting is chaired deliberately by the Chief Justice. Why? Because nobody is a member, there's no speaker, there's no president, there's nothing. We are still in the lacuna of the elections. That's why the Chief Justice presides over that meeting, my lady, until what happens? Until the speaker is elected. That's the end. The Chief Justice even has the power to determine when that meeting will take place. The minute people have been sworn in, if the Chief Justice went there and said, no, you must have a meeting next week, they'll say, what's wrong with you? And the reason for that is because those people, that is how the National Assembly manages its membership system. Not just on that first sitting, but throughout the 5 years. Where the IEC comes into this is nowhere. The IEC, I'm sorry.
Mr. Prof, within the scheme of things that you have just outlined,
Yes.
then how does IEC feature
Yes.
with reference to section 27? Because I think that there must be a start before you go to the National Assembly. We must have started somewhere.
Yes. Okay.
So maybe one might say your argument it puts the cart before the horse, because we need to start somewhere.
Correct.
As you have correctly pointed out, that in terms of section 190, the IEC is a body that is tasked with managing and
Elections.
managing and conducting elections. So that is their function.
Yes.
So that function obviously must include the entire section 27, submission of list.
Yes.
Because I'll tell you why I'm saying so. We have got section 47 of the Constitution.
Right.
Sorry, section 46 of the Constitution. That section says the National Assembly is composed of no fewer than 350 and no more than 400 men and women elected as members in terms of the electoral system that is prescribed by the national legislation. That national legislation, we know that it's an electoral act. Okay. Now, and that electoral system is based on the National Common Voters Roll.
Correct.
Now, in other words, the members of National Assembly are sourced from the candidate list. Is that not so?
Yes, my lord, that is so.
Yes. But is it not where the screening should take place when that list is submitted? Because once the screening has taken place, then those people, if they are elected, they go to the National Assembly.
No, they don't necessarily, my lord. That's what I was explaining
Yes.
to Justice Yakub. Those people will be members of the National Assembly if at that time, at the first sitting, they qualify. And think of it like this, my lord.
Well, let's say, for argument's sake, they get 20 or 20. So,
Or 200.
well, 200. Those 200 will go to the national parliament. Is that not so? Now it will be for the National Assembly now to do its function in terms of section
That's
1.
the point. That's the point I'm making.
Yes.
The point I'm making is this. You cannot say those, I think the number, I stand corrected, but I'm told that the number is around 15,000. There are about 15,000 people right now who have been, who are on the candidate lists of various parties, various levels, right? Now, those 15,000 people are not members of parliament. They are not members of the National Assembly. They are nothing. Members, Section 47, which deals with membership of the National Assembly, kicks in once those people are elected. That's why Section 19(1)(3)(b) says every person has a right to stand for elections, and if elected, to hold office. That bridge, or the election, is the bridge through which your Section 19(3)(b) election rights kick in. And that's the simple point we're making, my lord, is that you cannot then have the IEC exceeding its powers. And your lordship, I thought your lordship was going to Section 30, but we can start at Section 30.
That's where I want to go.
Yes, yes. Can I just finish this thought, and then I'll hear Justice Ndima. The answer to this, to what we're saying, is that we've said 191 is out. 192 says that you may also get power from legislation. So where in this instance do they get their power? It is anticipating the question from Justice McDavid. It is Section 30(1), right? Section 30(1) says that any person, including the Chief Electoral Officer, may object to the nomination of a candidate on the following grounds: that the candidate is not qualified to stand in the election. Not the candidate is not qualified to be a member of the National Assembly, because that's not their province, so to speak. Sorry, Justice Peter, thank you for allowing me to finish that thought.
I wanted to ask you, Mr. Mpofu, if the powers of the Commission to screen from the list whether a candidate qualifies, and I want to use the word from this section, qualifies
to stand in the election.
No, to be appointed into office, not to stand for the election. So it's the list.
Yes.
So let's look at section 30. 1A, right?
Yes, that's the one that just read.
It says the objection relates to qualification to stand in the elections, right? And then the Commission has the administrative authority to screen that list, to determine whether anyone is qualified to stand in the election.
No, normally, maybe they do have that power, but that's not the power that brings us here today. The power that brings us here today is the power that arises from the power of the IEC to determine an objection, right?
Yes.
So they did not exercise the power that they have. As you see, it says any person, including the Chief Electoral Officer, may object. They didn't. So that means, that's another thing that's wrong with this picture, by the way. That means that they waited for an objection, screened, not the candidate, screened, if you want, the objection. And then what I'm saying is that in doing so, they could only have exercised the power defined in Section 31A of the objection itself would be on the grounds that the candidate is not qualified to stand in the election.
Yes, but didn't they exercise their power in terms of Section 33? Because they made a decision on the objection.
Yes, but that's what brings us here. We're here to appeal the decision on the objection. That's why we're here today, is to appeal. They made the decision in 33 and then we're appealing. We can only appeal here in this court.
Yes, and hence my question to you, doesn't their authority arise from that section? You said they have no authority to make the determination that they made. And my question to you is that doesn't their authority arise from Section 33?
Okay.
Because that's why we're here.
My lady, you can't, the law doesn't work like that. You can only entertain an objection in the square of what the law says you can entertain.
Within the four corners of the act.
Absolutely. So they couldn't come and say, we want to object to this candidate, we saw them smoking daha. You can't. You have to, even if that's wrong to be an MP, they only have 3 grounds. circumscribed by the law. A, that the candidate is qualified to not stand in the election. B, that there's no prescribed acceptance nomination signed by this candidate. And C, there's no prescribed undertaking signed by the candidate. That's all. They have no other power. This is not a court of law. They have no inherent power. They only have the power that is circumscribed by the law, by Parliament, right? So, of course, I can object and say, no, this person is too short. But that's my objection. What the IEC must do is to say, okay, let's look into the list and see whether that fits into the list. If it doesn't, it doesn't, my lady. That's the point. It's a very simple issue of the rule of law. They can't say, no, we will just do we'll now screen you for membership of the National Assembly. Unless, if that was the case, the legislature would have listed it here. It would have said, the person may object to the candidate on the following ground: A, that you may not be a member of the National Assembly.
But the grounds are in section 47 of the Constitution. The qualification to stand for electoral office, as the criteria is set out in section 47.
No, but that's
and then
what
in terms of section 30, subsection 1 of the Electoral Act, the IEC has the power to then determine whether that criteria has been met.
No. The IEC has no, that's what we're busy discussing. The IEC has no power, unless someone is going to tell me where that power comes from, to determine the membership of the National Assembly.
Hang on.
Yes.
So it will seem to me that you are reading section 30, subsection 1A in isolation, because all that it says that it gives you the basis upon which an objection can be based.
Yes.
A candidate is not qualified to stand
in the election.
But it doesn't tell us what is it that will render a candidate not being qualified to stand in election. That statement or that explanation or that ground we find in section 47 of the Constitution.
No.
You can't, Mr. Professor, you can't read section 31A in isolation, because section 31 in isolation doesn't provide the meat to the skeleton. All that it gives you the skeleton. It says this is the basis upon which you can
let me
raise an objection.
I really need to move to the merits. I'll just make one submission.
Sure.
And stand or die.
Yes.
What we're busy discussing now is not the merits of the issue, it's the locus standi,
the authority.
The authority. And we're saying that authority cannot be implied in the manner that your Lordship said. That authority must be spelled out. If it's about disenfranchising human beings, it has to be. We can't say, well, therefore X is Y and Y therefore is Z. The issue is that...
Well, then in relation to the qualification of the candidate...
For the election.
Sorry. In relation to the qualification of candidates, in your suggestion is, where does the authority of the IEC start and where does it end? Because you say that when it comes to section 47 qualification, they do not.
It's a matter for the National Assembly.
They do not have authority, because it's a matter that falls within the province of the National Assembly.
Yes.
So let's see. Let's deal with the extent of their powers within the context of...
Yes. You see, my Lord, let me give you an example. There's a reason why the section starts by saying every citizen who is entitled to vote has a right to stand to be a member of the National Assembly, for example. Why? If you're not a citizen, then you are not qualified to stand in the election. Okay? That's just the clearest example. Yeah. So, but there is nowhere that says if you are not eligible to be a member next year of the National Assembly, you are not qualified to stand for the election. That's the point, and that's really the simplest way to explain it. That if we agree that the National Assembly is the body that administers its own membership throughout its 5-year term. Then we have to ask the question not in this way of implying. We have to ask the simple question, where does the IEC get the power to determine the membership or non-membership of the National Assembly? And it's nowhere. Now let's move to the merits.
All right.
Assuming for a minute that the IEC has this authority from where I don't know, then it would then go to Section 47.1. Section 47.1, again, is an exception. So the person who wants to invoke the exception, we know that in law. Anyone who wants to invoke an exception must establish all its existence, as it were. It's not for us to say. For us is to say Mr. Zuma is a citizen of the country, he's entitled to vote, and therefore is entitled to stand for election and to hold office. Someone who says there's an exception, which is in this point of IEC, must tell us whether that exception holds. Now, we have a strange situation here, by the way, where the person who actually raised the objection is not even here. The IEC has now taken the cudgels of the objector and is fighting tooth and nail to exclude Mr. Zuma. Why? The IEC is not, should have no interest in this. It's a referee, not a player, supposedly. So, but now the IEC
but it is here to defend this decision.
No.
I understand that the objector is not before us.
Yeah.
But now a decision that is
Taken by
us
IEC.
is a decision that was taken by the IEC, and the IEC is here to defend that decision.
No, my Lord, your Lordship is misunderstanding me. I'm the person who brought the IEC here, so I can't say the IEC shouldn't be here. We cited them as first respondent, so that's not what we're not saying it shouldn't be here.
Yeah.
I'm saying something completely different.
Okay.
I'm saying, having been here, the IEC gets cited in all sorts of matters, and sometimes they abide, sometimes they participate. So I'm saying the manner of participation for an independent body cannot be this belligerence and fighting tooth and nail and accusing MK party of violence, bringing in irrelevant issues. That you expect from the adversaries of the MK party. Yes. If another political party accuses MK party of having horns, that's fine. But not the IEC. The IEC is now acting as an adversary in the true sense, and that's significant.
But I think that point has been well addressed by
in the reply.
In the reply.
Yes, it is.
So I'll leave
there. And it's also important for the issue of bias that my learned friend will address, and the issue of what we ask the court to do, really, to warn the IEC that it must not descend into the arena. It must not get into this hype that it has gotten into over this matter. Because after all, it's not the IEC that objected. So this is what we're saying, Madam. That the broad statement is that you should not be exclusionary in your mindset. Now let's look at the section 47.1. It has two important requirements, or three. One, you must be convicted of an offense, right? To save time, let's assume that the debate about whether it's an offense or not is determined against us, in the sense that the courts have said it's a so-called hybrid. So let's assume a hybrid can be half of what it is, and you can categorize it like that. But here's the question: the conviction. Can it be said that the drafters of the Constitution, when they use the word conviction here in Section 47, envisaged a normal conviction which has gone through the ranks of the Criminal Procedure Act, Section 35 of the Constitution, where the person has enjoyed their rights, or surely, that's what it means, surely. I mean, one doesn't do that. When they say conviction, they mean that. We know what a conviction is. You get accused, you plead guilty or not guilty, you cross-examine witnesses and what have you. Now, the
question that you are raising is whether he was convicted as contemplated in section 47(1)(e).
Yes. I'm saying when in interpreting, remember we use purposive interpretation.
Yes.
The purpose of including that particular part by the drafters of the Constitution, was it directed at conviction as we all know it, or some conviction that has never happened in the history of mankind, where the person has not had their Section 35 rights by the mouth of the Constitutional Court, by the way. Unlike what my learned friends are saying, Justice Kampepe's judgment says that this person is not entitled to their Section 35 rights. She explains why, but I'm not interested in that. But she says he is not entitled to those rights. He's not entitled to the right of appeal. He's not entitled for whatever good reasons. Let's assume there were good reasons. But that's the issue before this court. Did the drafters of the Constitution contemplate such a thing, or did they contemplate what we all know, a conviction which follows all these normal steps? Now, we then say, if the answer to that question is, as it must be, that surely, I mean, you must put yourself in the shoes of the drafters of the Constitution. By the time they drafted Section 47, they knew about Section 35. Yes. They knew that when you are convicted, you would have enjoyed all your Section 35 rights. So that's what they meant. They could never have meant some conviction sui generis that is unconstitutional, quite frankly. So and it might well be as it was said. I'm not here re-arguing the matter of the Constitutional Court. There might have been good reasons or bad reasons or whatever. But the point of the matter is that we all know that there was no trial, there was no plea, there was no charge, there was no standing in the dock and say, are you guilty or not guilty? None of the things that we know go with a conviction happened. The only person in the entire country of 62 million people who sat in jail without ever having said, I'm guilty or not guilty, is Mr. Zuma. Now again, we want the only person who's disenfranchised to be Mr. Zuma.
It sounds to me that you are re-arguing. Wait, Mr. Mpofu. It sounds to me that you are re-arguing the issue that served before the Constitutional Court when it determined whether Mr. Zuma is guilty. Mr. Mpofu?
Yes, I'm sorry, my lady. If you forgive me, I'm just trying to save time while you are talking. I'll listen, I promise you. I'm just...
just listen to the question, and then if you need an answer,
then
you can go to your
language
papers.
matters.
Thank you, lady.
Yes. Okay, listen to the question, Mr. Mpofu.
Yeah, I'm saying it sounds to me that you are re-arguing the issues that served before the Constitutional Court when it determined whether Mr. Zuma is guilty of the crime of contempt of court and what sentence ought to be imposed. Right? Shouldn't the starting point here be the order of that court? Because that order stands, whether it was correctly or wrongly made. That's not what we are concerned with. That's not what we should be concerned with here. Even if it was wrongly made, and if it was, in fact, it's not for me to even voice an opinion on that, or even offer a perspective on that. Even if it was wrongly made, that order stands. So shouldn't be the starting point, the wording of that order and what it means, and not whether that order should have been made or not made.
Can I speak now? Thank you.
Yes.
Thanks. My lady, the reason I apologize, the reason I say is because a minute before your ladyship asked me the question, I said here, I am not re-arguing that matter. That whether it was right or wrong, even if it was wrong, what can you do? This court can do nothing about it. Yeah. So I'm not doing what your ladyship
I'm
saying.
trying to just focus you on the wording of the order and not why the order should not have been drafted.
No, I am not arguing why the order should not have been done. I'm not. I will never do that.
Okay.
Ever. Yeah. Okay. This is what I'm saying. This is what that court said, my lady, in paragraph 79, just as an example.
On what page is it?
78 of the or 39 of the type page and 78 of the.
Also, give me the paragraph number.
78.
Yeah, in fact, it's paragraph 79 of the judgment, and your ladyship can start at. Okay, let's start there because the court is probably there. I'll come back to the other one. It says, whilst this judgment indeed cannot be appealed.
Sorry, you're reading from which paragraph?
79 of the judgment.
It's the second sentence.
Second sentence.
Yeah,
Sorry.
it's here. Sorry. Is it the same judgment, 2022? Which judgment
There's
is
the judgment that's
it
part
the
of
one
the
that we have just
objection.
set it up?
It's the one that is part of Dr. What's his name? Matsapule's objection.
Yes.
That's the
Just
one.
read it
Oh, I
because,
see.
yeah.
Okay.
Just read. Is it
So
the
you're
one that's
reading
starting
from
with
the-
firstly?
No, yeah, he's reading from the fourth line towards the end of that line. The next sentence starts, while this judgment. Is that not so, Mr. Mboko?
That is so.
Okay, that's
Thank
correct.
you.
Yeah.
It says, whilst this judgment indeed cannot be appealed, this is that court saying it itself. Okay,
Yes.
it's not me saying it was good, wrong, or right. Assume it was right. Not about right or wrong. It says this judgment cannot be appealed. And then it says, paragraph 80, secondly, I've already explained, Mr. Zuma simply does not enjoy an accused person's right of appeal. It's the judgment. I'm not saying, in fact, I'm saying it's right. Let's assume it's right.
Yes.
Yeah, so that we not get caught in this thing about re-arguing. Assume this is right. This judgment rightly says Mr. Zuma simply does not enjoy person's right of appeal. And then it says, if you go to page 20, which is in the notice of appeal, my lady, paragraph 23, we quote there. Is the court there?
Appeal.
Yes, notice of
Paragraph?
appeal. Paragraph 23, my lady.
Page
20. Right. Justice Kampepe says, so nobody is saying this is wrong. In fact, we say here correctly. We say, to this effect, Kampepe ACDJ correctly pointed out, quote, it is not a conventional criminal trial, and that a respondent in contempt proceeding is not an accused person as envisaged by Section 35 of the Constitution. I'm agreeing with the judgment, not saying it's wrong. But I'm saying that being right, if we know that here we have a different animal to what we know a conviction to be. One where there's no right of appeal by the mouth of the court, where there's no right to a fair trial by the mouth of the court. And the only submission I make is that surely anyone interpreting a constitutional statute, which you must interpret generously in favor of enfranchisement, cannot find that the word conviction should be restrictively interpreted to mean anything goes. It must mean a conviction as we know it. So that's the point about conviction.
Sorry. You said that the word conviction should not be restrictively interpreted.
Yes, I'm saying, my lord.
Or it should be. I think that it's the other way around.
Why do? Yeah. No, okay. It should not be, I'm saying, well, restrictively of rights, maybe that's what I mean. But your lordship is quite correct. What I'm saying is that when I say anything goes, is that one should not include any old thing that might happen, and then impose that, as it were, to the purpose of the section. Now let's go to the interesting part, the sentence. This, I'm afraid, is where the whole house of cards falls
So before
away.
you go to the sentence, I just want to recapture your case so I understand.
Yes.
In a nutshell, you are saying, because Mr. Zuma was not convicted following criminal proceedings, Section 47 does not apply. That's your case?
No.
Yes,
I'm
what are you
saying,
saying?
no, that's not what I'm saying. I'm saying, remember, this is an interpretation exercise.
Yes.
So I'm saying, interpreting that phrase, convicted for an offense,
Yes.
we have to, notionally, of course, transport ourselves into the drafters of the Constitution.
Yes.
Now, I'm saying when they did that, they could have only meant a constitutionally compliant conviction which had followed Section 35. Not one which has
that's
not,
what I'm asking.
not
Are you
one
saying-
that has, by its own terms, not
Yes.
followed Section 35.
And that would be criminal proceedings as conventionally.
Yes, remember.
In the
as
conventional
just-
sense.
Yes.
That's what you're saying.
Yes,
yeah.
yes, that's what I'm
Okay.
saying. That's what Justice was saying. That as when I say as we know it,
Yeah,
I'm using
the
shorthand.
conventional
We
sense.
know, I've been pleading guilty.
So because he
standing-
wasn't charged, he didn't plead, he didn't go through a criminal trial, was convicted as a result.
and did not
in that
enjoy
trial.
any of the Section
35
rights.
rights.
Yes.
Okay.
And I'm saying that there is, well, this is not about that case, it's about interpretation.
Yes.
All I'm saying is that the purpose of this constitutional clause could not have been to envisage some conviction which doesn't accord with Section
So
35.
you are saying, since he was not afforded Section 35 rights by the Constitutional Court,
By its own mouth there.
then the conviction that was meted out by that court does
Doesn't
not
meet
fall
this-
within the purview
Of
of Section 47. That's your case.
That's correct, ma'am. Now let's move to the
Can I
interesting.
follow up? Sorry, Mr. Mako.
Sorry, thank
Can
you.
I follow up?
Yes, yes,
I
Professor.
just need a clarity. Whether there's a distinction between an offense
Mhm.
and a crime,
Yes.
which would have led to a conviction.
Yes. No, I'm not taking that point. That's why I'll say it to save time. I can assure you that even the issue as to whether contempt of court is a crime is very vexed. We all know. There are cases, Machabeng, that they rely on, Pego, there's this case, there are cases of Faki and so on, where it's said that it's a hybrid. Even Justice Hamburg said so. So I'm avoiding that debate.
But hang on. You can't avoid that debate because I think that debate is critical in this case, Mr. Mpofu. Contempt of court. According to the Concord, he was convicted because of contempt of court,
Yes.
which is it's an offense. You say that you don't want to get into the
No,
debate,
okay. Let me make it easier like
but
this.
how can we deal with this? How can we argue in a way that will satisfy everybody without dealing with whether or not there was an offense here?
You can, my lord. Remember, this is a phrase.
Yes,
Right?
yes.
What does the phrase say? Convicted of an offense.
Yes.
So I'm allowed, my lord.
Offense is there, it's
Yes,
in the statute,
it's
so
part of the thing, but it has two.
we can't run away from
You
it
can,
because it's
my lord.
there. It's in the section.
Yes, it's there, my lord. But you can, if you say, if the section says, my lord, you must bring apples and oranges. Then I say, okay, I accept that you've got the apple, but you don't have the orange. I'm allowed to do that. So I'm saying, even if the
But is it a correct way of interpreting a statute? Because when you interpret the statute, each and every word counts.
oh my lord, I'm sorry.
No,
I don't have to dispute every word.
no.
I could say if someone
What does Ndumeli tell us, Mr. Mpofu? The approach to interpretation of the statute or the interpretation of the document.
my lord, okay, let me do
We start with the language first.
All right.
The
Let me do-
context.
Okay, I'll make it easier for the context.
Yes,
I hope I'm allowed to do this.
sure.
This thing has two. If someone is being charged with murder, right? They say you killed a human being. You might dispute that it's a human being, or you might not. You're not forced to dispute. You might dispute intention. You might dispute unlawfulness. You might dispute any element. So I'm saying, assume for the purposes of this argument that I concede that it's an offense.
Yes.
Okay? I'm saying that cannot be the end of it, my lord.
Okay.
The issue is, was he convicted of that offense? So the court can't
Okay,
then say...
that's where you are.
Yes.
So, okay.
I'm simply...
We can proceed on the assumption that you accept that there was an offense.
Yes.
But now you say there was no conviction.
Yes, that's where I started,
Okay.
my lord. I said there's a very big debate in Machabeng, in Pego, in all these cases about whether it's an amalgam or it's a crime or it's a civil contempt. Or I don't want to enter into that. So for the purposes of this argument, assume that it was an offense. I'm saying, but the issue I'm disputing is whether he was convicted. So it could have been, forget about that it's a sui generis thing. Let's assume it was just normal theft or robbery or whatever, so, which we all know is an offense. But the fact that that is a well-known offense cannot deprive me the argument that the conviction as envisaged in the section is not a conviction. This is all I'm doing.
But Mr. Mpofu, it's the fact that it is sui generis which gets us to this point in the first place. So the conviction is open to interpretation because it is a sui generis situation.
Yeah. But, my lady, I'm saying that the conviction you have here, for whatever, sui generis or not, is not a conviction as understood.
Yeah.
That's all I'm saying, really. I can't put it further than that. Whether the crime is X, Y, or Z, or whatever, doesn't go to the point I'm making.
Okay, but so, and if you are prepared to accept, for the purposes of the argument, that this was an offense, does that mean that this court is bound to accept that it was an offense?
Yes, of course it is. Well, once counsel says that for the sake of the argument, let's assume this leg is not in contention, but I want to contend this one. Of course, the court is entitled to.
Is entitled, but is it bound?
No, it's not bound. It's not bound unless if I was putting it higher. If I'm saying for the purposes of argument, those words mean for the sake of progress.
Yes.
So that we can move on, because I don't have a lot of time.
Sure, yeah, the time is
Otherwise, I can contest every comma, every word, I don't want to do that. I want to only contest what I feel is because remember, my lady, as I say, I'm not being facetious when I make this example of murder or theft. In law, everything has elements. So there might be 5 elements. I can say, no, I'm not worried about these 2 elements. But if these 3 are not there, the crime is not there. That's really what I'm doing. Now, so let's go to...
We're moving to a
sentence.
Subject or the sentence.
Yes. Thank you, my lord, and I hope your lordship will give us some leeway because of the interaction which we welcome. My lord, I was saying before this interaction that the issue of the sentence, if anything, this court can decide this matter on that issue alone. Assuming the court even reaches the merits, assuming the court says the IEC has some power to administer Section 47. Here is the issue, madam. Let's go to what the Constitution actually says. It says, let's put it this way. The Constitution makes it clear in Section 47 that what it is interested in is what we call the ultimate sentence. Again, it's a purposive interpretation. The reason why the Constitution could have just said if you are convicted and sentenced to a crime for more than 12 years, full stop, right? But it didn't. It went on to qualify, and words, even in a statute, must be assumed to have meaning and a purpose, let alone in a constitution. It went on to say, but one may only be regarded or deemed, as we say in law, of having been sentenced. No one may be regarded as being sentenced until an appeal against the conviction or sentence has been determined. Let's just pause there. So, on a purposive interpretation, my lord, it's clear why they put that proviso. Because they say we're interested in the ultimate sentence, not the original sentence. And the ultimate sentence could have been a result of an appeal, And that word, again, to go back to the wide and strict, must be interpreted widely, my lord, to mean anything that might reduce that sentence must have happened or not happened. So let me give you an example, my lord. If the person had not appealed but applied for a rescission, and then it's set aside,
Sorry. We are within the context of the criminal law. So rescission now, where does rescission come in?
Well, my lord.
Unless, of course, if you want to say review, then I would understand.
Okay, let's say let's make it easier.
Because that's the only way you can achieve the setting aside of the court order on conviction and sentence. It's either by way of a review or by way of an appeal. So let's stick to.
There's the Rule 42. Actually, this case we're talking about actually went on Rule 42, but that's fine. Let's leave that.
Yes.
And two judges of the Constitutional Court declared that it should be set aside as a rescission. But let's leave that. Let's use a review.
Okay.
If the sentence, for argument's sake, was set aside by way of review,
Yes.
you can't then say, no, but the section says appeal. Because that's not a purposive interpretation. The purpose is to find out what ultimately happened.
Yeah.
No, the normal, again, it goes to the normally it happens by way of appeal. But it can happen by way of review, it can happen by any other method. But the point I'm making, which I really want this court to remain with, is that Section 47 concerns itself with the ultimate sentence. Right. Now, if we accept that, then we make two criticisms. One is that this one was not even appealable, so that's part of Section 47 it becomes irrelevant. But that's a separate point. It's the similar point. I don't want to develop it because it's a similar point like the one I made on conviction about Section 35. All it means here is just Section 35(3)(o), which deals only with appeals and or review.
Yes.
Yes. But here's the bigger point, my lord. In this case, it's common cause that Mr. Zuma was then admitted to remission by the President of South Africa. That remission is common cause as well, and the SCA found this, that the portion that he had served was 3 months, right? And we argued, at least I argued, unsuccessfully, thank God, that the sentence actually had been served, but that was rejected. The court said, no, that sentence, he has only served the sentence up to the time when he was unlawfully paroled. You'll find that, and I think the implications of that are now coming home, because that court said at page 24 of the paper, paragraph 43, we quote what the SCA said, which is binding.
Page 24.
24 of the papers, 43, paragraph 43 of is the notice of appeal, madam.
Notice of appeal.
Yes.
This is what the Constitutional Act, the SCA said unanimously. The effect of setting aside the declarator is that once the order in this appeal is handed down, right, which was about August, Mr. Zuma's position, I'm going to say this one slowly, is as it was prior to his release on medical parole, will be reinstated. What does that mean? Once we pronounce this, as at the point at which he was unlawfully paroled, his position is there. That is at 2 to 3 months. That's what the SCA says. They say, in other words, Mr. Zuma in law has not finished serving his sentence. He must return to Escort Correctional Center to do so. Okay? So far, so good. So we know how much he has served at that point is 2 to 3 months. What then happened is that as he reported, as ordered by the court, at Correctional Services at Escort, he then was given remission of sentence. And that means it's a symbol, the ultimate sentence that he had was the 3 months. Now, remission, my lord, it works like this. And this is where my learned friends confuse these terms. Remember, it comes from section 84.2J. And that section of the Constitution, it comes from the so-called, it's the remnants of our colonial past, what used to be called the prerogative. So the reason why this is only left to the president and not even to a minister or some correctional services people is because, as it has been said, it's like a favor, it's just amnesty. It actually undermines the courts. I think that's what people say.
Yes, that's one.
Yes.
The question, Mr. Mpofu, what is the legal effect of remission
yes, I'm coming
on the
to
sentence?
Yes,
that's a
yes,
question.
that's really what I'm addressing,
Yes.
my lord. But I have to start by situating it where it comes from.
Right.
Okay. It says at section 84.2J, the president has the powers entrusted by the Constitution and legislation, including whatever, and as the head of the executive, the president is responsible for, in J, pardoning or reprieving offenders and remitting any fines or penalties or forfeiture. That means pardoning and remission of sentence. Now, the mistake my learned friends make, they say in their defense, but Mr. Zuma was not pardoned. We agree. Mr. Zuma was not pardoned. The difference between a pardon and a remission is very simple. A pardon is where you forgive the conviction and the sentence. That's a pardon. It's called a pardon. Remission is where you only forgive the sentence. That's all. It's not rocket science. And so what we are saying is that at this point, if he was pardoned, then we would be saying, my lords, scrap both the conviction and the sentence, but this is just about sentence. So the effect of remission has been clearly described. In fact, the synonym for remission is to cancel. Cancel, and in the thesaurus, it even says to set aside. That's the best way.
Sorry, Mr. Mpofu.
I'm sorry, yes.
If I understand you well, you are saying the effect of remission is basically to extinguish the remainder of that particular sentence.
Yes.
And as a result, that would not amount or qualify as the 12 months as per section 47.
Absolutely. Thank you, Professor. So the ultimate sentence, remember we said in section 47 searches for something called the ultimate sentence. That's why when it says you must wait for the appeals to be adjusted, whatever, it's all about what should be the ultimate sentence. So in this case, the ultimate sentence, as a result of a remission, not as a result of an appeal or a review or anything, is 3 months. And here, I'll hand this up. This is what it says in the thesaurus. Remission is a noun. It means cancellation, setting aside, suspension, revocation. And that's the first example. But the law dictionary, the Oxford Law Dictionary, says remission is cancellation of part of a prison sentence. So all of them, Professor, you're quite right, talk about cancellation, extinguishing, but the one I like is setting aside. In other words, once the sentence is set aside, whether it's set aside as a result of an appeal or a review or remission, it is set aside. Now, the point is this. We're dealing with a penal statute. A penal statute has to be interpreted restrictively. We're not only dealing with a penal statute, we're dealing with a penal statute that takes away political rights from people. That's even worse. It means that there must be even further caution. So how can we say when the statute, or rather the section, is clearly directed at the ultimate sentence, then we say no, forget about that. Forget about the appeal, forget about the review, forget about the remission. I call their defense finish and clap. They just say, look, He was sentenced to 12, convicted, sentenced to 12 months, finish and clear. Forget about the rest of the section 47. Don't read it. Stop at where it says 12 months. You can't do that. The whole point of the drafters, including those words, was not to play. It was to make sure that what it said at the governing section, every citizen has a right to vote and so on, except. So the exception has to be interpreted in that manner. So, what does that all mean? What it means is that if the effect of the remission, and your lordships will find in the cases, the bundle, our bundle that we just ended up, we'll find two cases that we refer to. Smith and Bushiho.
Yes.
Let's start with Smith to page 58, page 58 of our bundle. And I won't read the long passages because of time. This is what Smith says in paragraph 34.
Yeah, you have to wrap up, Mr. Mpofu. We have gone way beyond your allocated time. But yeah, okay, that's fine.
It should be noted at this stage that it becomes very important.
That's page 58, ne?
Paragraph
34.
34.
Yes.
It should be noted at this stage that it becomes very important for the applicant to determine from which sentence the 24 months remission should be deducted, extinguished, cancelled, whatever. And then it says, at paragraph 39, the following page, what becomes one is the effective term of sentence. In that case, we were talking about concurrent sentences, which must be served. Remission and parole will be considered in relation to the length of a term of imprisonment. In other words, both cases, both Bushiho and Smith, were concerned with the following question. From which, what is X? If you say remission is 1, and if you have X minus C, let's say, or R, X minus R, which is the remission, what is what then remains? So that you can then apply the parole. I'm paraphrasing for. So this is what happens in real life. If the president says, I'm giving a remission of, let's say, 2 years. If I have a 20-year sentence, that sentence becomes an 18-year sentence. But if I've already served, I'm only left with 2 years, let's say, then I get released. But both of us, it doesn't matter. The fact that I go home and you don't go home doesn't really matter. It's simply because my sentence was towards the end. But the remission is applied to both of us exactly in the same way. And that's why the court said that.
But when a remission kicks in, does it affect what is recorded in the so-called SAP 69? Because that is where the previous conviction are recorded in the SAP 69. If somebody was sentenced to 15 years imprisonment, and then along the way he get paroled,
It's still a 15 years.
what is going to be reflected in the SAP 69?
My Lord, the answer is I don't know. But that's not the point we're making. The point on that question can also be asked about what happens if your sentence was 20 years and then you appealed, then it was reduced to 10.
If it's reduced on appeal, then the SAP 69 will be changed.
Exactly. But that's the point we're making. If it is reduced, if your sentence, your ultimate sentence, is reduced to 3 months for whatever reason, remember that's where we started. We said the purpose of the section was to look at the ultimate sentence. So whether that ultimate sentence happens, okay, let's come to the other example you made, my lord. If it's set aside by way of review, the SAB 69 will also show that it's zero. It's the same effect, my lord. That's what we're saying. That's why they say in, I think it's the case of, if your lordship just bears with me, I don't know if I think it's yes, right. Paragraph 66 of Smith, it's on page 67 of our bundle, answers that question squarely.
Yes.
Okay, it says the total sentence, remember here, of the applicant was to serve was 18 years. Put there 15 months, right? If the 24 months remission was deducted from this sentence, it would leave a sentence of 16 years imprisonment. A sentence, not anything else. So the sentence that would remain after you've taken the remission would be a sentence of 16 years. So let's bring it home. That sentence would then read like this. The total sentence which the applicant was to serve was 15 months. If the 12 months remission was deducted from this sentence, it would leave a sentence of 3 months.
So, Mr. Mpofu, under normal circumstances,
Yes, ma'am.
it's a court of appeal or a court sitting in review proceedings that may interfere with the sentence that has been imposed, right? That's under normal circumstances.
Or a conviction.
Yeah. No, I'm not dealing with the conviction. I'm dealing with the sentence, which is your case, right? You're not disturbed by the conviction. You're not impugning the conviction here. We're here because the issue is whether the ultimate sentence remains that imposed by the Concord or whether the President reduced it, right? Now, essentially, you are saying there was no appeal here. There was no review of the sentence imposed by the Concord, right? That's common cause.
Yeah.
The President then exercising his powers in terms of section 84(1)J remitted the sentence. And the effect of that is that he interfered in the same way a court of appeal would. He interfered with the sentence that the Concord imposed, and as a result, the sentence was no longer 15 months, it was 3 months. And that is why when Mr. Zuma reported to the prison, he effectively walked. Yes. Because the remainder of the sentence had been interfered with. It was no longer 15 months.
Absolutely.
It was 3 months, which he had already served.
Yes.
And that's why he was allowed to go home.
I couldn't put it better than that. And the issue of it was extinguished by a lawful process, which is the reduction, cancellation, setting aside, whatever you call it.
Presidential remission.
Of a presidential remission, yes. Which is different. That's
So,
why,
sorry, Mr. Mpofu, it's not the entire sentence which was extinguished, it's the remainder of the sentence.
yes, it extinguishes the remainder. No, that's what I just said. The Oxford Law Dictionary says the remission is cancellation of a part of the sentence. Yeah. So no, we're on the same page. But that part is that's what Justice Modiba is saying. That part is the 12-month remainder. The part of the sentence. That's what we're saying. We're not saying he goes back to zero. No, the 3 months stays until the point, just as it would happen if it was an appeal. I think Justice Modiba has put it that at that point you can't say if you've been sitting for 6 months.
I think that you have covered all the points, Mr. Mpofu. Your points were bias, ultra vires, conviction and sentence.
No, bias.
Oh yeah, sorry. So your colleague is still going to address us on bias.
Yes.
Yes.
My Lord, let me round it off like this. We are dealing with a very serious matter.
Yes.
Of wanting to disenfranchise possibly millions of people so that they don't have the choice of the leaders that they want. Number one. Number two, forget those millions of people or however many they are. We are dealing with an individual, a citizen of this country, who fought for this freedom, who says, my rights in terms of Section 19 are being violated. And thirdly, we're dealing with the rights of a political party. It should not be easy, my lord, for the IEC to just receive some piece of paper and the following day they scrap you out of history. It should not. And it should not be easy for this court to say a provision that does that must be interpreted to close our eyes, for example, to the remission, and say, no, we don't care, whatever happened. We are interested in the original sentence, not the alternate sentence. When it is plainly clear that the statute is interested in the alternate sentence.
Yes.
And therefore, my lord, whether the element that is missing is the element of the conviction, and that's really that's why I was not concerned about whether the crime and so on. Whether that is the element of conviction or the other element of sentence, because of the word "end." Once one of those elements is missing, then it should not apply. And remember, the writers of the Constitution even tried to make it even easier. They say after 5 years it expires anyway.
No, but that doesn't concern us.
No, it doesn't. I'm simply making the point that the statute, rather the writers try as much as possible to limit the ambit of Section 47. So those are our submissions, members of the panel. Firstly, we should not even reach this debate because the IEC overreached and encroached on the domain of the National Assembly. But if we do reach the debate, then certainly Section 47 is not implicated.
Okay. Thank you.
My learned friend will deal briefly with the issue of bias, but maybe just 1 second, please. I just want to situate this in the statute.
What is it you want to use?
Electoral Commission Act. I have copies of Section 4.
Which section, Mr. Mbofu?
Section 9.
Section 9.
Thank you.
Does it deal with bias?
Yes.
But now why can't you allow your colleague to deal with
No,
it? Why do you want to? why do you want to contextualize it?
Can I explain, my lord?
Yeah.
I said to your lordships that one of the issues I'm going to deal with is the issue of the conduct of the IEC vis-a-vis the issue of the disposition. Now I'm saying, and whether
With regard to the issue of
their attitude, disposition, and conduct.
the manner in which they have handled this matter.
Conduct.
Yes.
Actually. Now I'm saying, I'm linking. All I'm doing, my lord, is I'm linking that section with what my learned friend is going to address you on, if I may.
That's Section 9 of the Electoral Code, Electoral Act.
The Commission.
The Commission Act,
Commission Act.
not the Electoral Act.
Not the Electoral Act.
Electoral Commission Act. Yes.
All right. Now I'm saying vis-a-vis the conduct. My learned friend will talk about the specific issue of commissioner law.
Yes.
I'm making a broader point. I'm saying every member of the commission shall serve impartially and independently and perform his or her functions as such in good faith, without fear, favor, or prejudice. Shall. And then it says a B, the number 2B. Every member of the commission shall, or rather, no member of the commission may, whether directly or indirectly, in any manner, give support to or oppose any party or candidate participating in an election, or any of the issues in connection between the parties or candidates. And I'm saying that those sections cut two ways. One, it's about the conduct of the IEC, which has come here not as an independent party, but as a combatant. And that also links to the question of the specific conduct of Ms. Lau. And that's what my learned friend is going to be addressing.
Thank you.
Before you sit down,
Sorry.
Mr. Mbofu, please give me the citation, the provisions that you read.
Okay, yes,
It's
my lady.
nine
Yes,
what?
it's 9(1)A, my lady,
Okay, yes.
and then 9(2)B. of the Commission Act.
Thank you.
As the court persists. I mean, that's up to the court.
Thank you, Mr. Mbeki. Yes. Yeah. So you are going to address us on bias now.
Yes, my lord, I am.
So sorry, your 15 minutes starts now. It's 12:11 now.
As a piece of report, my lord, I'm indebted to your indulgence.
Yes.
My lord, on or about the 24th of January 2024, Commissioner Janet Love made a public statement at a press conference held by the Commission, wherein she made a pronouncement on the eligibility of the second appellant with regards to his candidacy for the upcoming elections. My lord, I will take you through the statement shortly. However, following the statement that was made by Commissioner Janet Love, there was a media report that was released by Eyewitness News that was headed that the second appellant is not eligible to stand as a candidate in the elections. In this regard, my lord, it is important to note that neither did Commissioner Janet Love nor the Commission itself ever refute the statements that were made in that report, nor did they ever correct the statements that were made in the reports, which they have the right to do. In this regard, my lord, it is clear that the Commission had prematurely prejudged the issue regarding the eligibility of Mr. Zuma, and it could not have arrived at a fair and different outcome. My lord, it's on this basis that we argue that firstly, Commissioner Janet Love ought to have then recused herself from deciding the objections that were entered against the appellants. Alternatively, that the Commission itself ought to have required her to recuse herself from the decision in order to ensure impartiality, which my senior counsel has indicated to this court is required of the Commission in terms of Section 9 of the Electoral Commission Act. In this regard, the IEC has denied our allegations firstly, but has presented the following defenses.
Yes.
Firstly, that the Commissioner simply stated the legal position. Secondly, that the statement was made in response to a question rather than on her own accord. Thirdly, that the IEC is not responsible for the headline. And lastly, that no reasonable observer of the press conference would have arrived at the conclusion that the IEC made a decision and confirmed that Mr. Zuma is not eligible to stand as a candidate in the elections.
But do we have the actual statement that was made by Ms. Love, or is it based on the media reports?
My lord, it is based on
Paraphrasing what Ms. Love must have said. I don't know whether is it the actual is verbatim or it's paraphrasing of what she's alleged to have said.
My lord, we rely on both.
Yes.
Both the statements that were made at the press conference and the statements that were quoted in the media report. My lord, if I may please just turn you to page 225 of the bundle.
We don't have a paginated bundle.
So you are referring us to something that we don't have. Okay,
Apologies.
just refers to, you can just say founding affidavit or, because it might be in your founding affidavit. Let's go to your founding affidavit.
Yes, my lord. In terms of our
Or
notice
to,
of appeal,
Notice of appeal, sorry.
yes, it's annexed to our
Just
notice of
give us
appeal
a
as
sec,
Annexure
just want to
D.
go there.
Annexure D.
Yes.
Thank
my
you.
lady. You'll see Annexure D is a copy of the report by Eyewitness News. And then we turn over to the second page of the report. It starts off with, since Zuma became the face of his new political party.
What annexure is it?
It's Annexure D to the notice of appeal.
And what document is that?
It is the media report that was,
document.
yes,
Media
exactly.
statement, you're right,
That is
yeah.
the exact
And then the
document
press
that I'm referring
statement.
to, my lady. My lady, first you will note under the headline Zuma not eligible to register as a candidate for elections -IEC, it states that the Electoral Commission has on Thursday confirmed this when asked at a press briefing whether Jacob Zuma could be included on a party list for election to Parliament. Okay, so that was the question that was presented to Commissioner Janet Love. If I may please turn you to the second page of the report.
Media statement, right? Press statement you're still on.
Yes, my lady.
Because you've just said report.
Apologies.
Okay.
So
When
now you
when
went
saying media
DE.
report, I mean the
Press statement.
press statement. Yes, my lady.
Yes.
My lady, if I can then direct you to the fourth paragraph. The paragraphs are numbered, but it is the fourth paragraph. This is the response to the question whether Zuma could be included on a party list for elections. It reads, that excludes anybody who has been given a sentence that was not the subject of any deferral. And in that sense, it is not ourselves, but the laws of the country that would stand as an impediment for that candidacy. I intentionally place emphasis on the words in that sense, it would stand as an impediment for that
So
candidacy.
where do I find those words?
My lady, you find them in the direct quote on the second page of the.
This
of
is
the
still
news
in the
statement.
report.
Yes, my lady.
Oh, I see. The
Yes.
second sentence.
Yes.
Okay.
So the fourth paragraph. My lady, if I may, I would like to, my lord and my ladies, if I may, I'd like to break
Sorry,
this
but
down
in
further.
that statement, is there any reference to Mr. Zuma? Other than a question was posed and the answer, I'm not sure whether the answer was specific or was in general.
My lord, our submission is that this statement was specific to Mr. Zuma, and I'll explain why. We have already established that the question was specific to Mr.
Yes.
Zuma. Now, with regards to whether the answer was specific to him, I would like to draw your attention to the last line of that paragraph, which says, okay, it would stand as an impediment for that candidacy. Not a candidacy, it's definitive in its meaning. That she is responding to a question regarding Zuma and is saying, in respect of his candidacy, essentially, there would be an impediment to his, there would be an impediment. Let me break this down further, my lord, if I may. The word that excludes anybody who has been given a sentence that was not the subject of any deferral, we can accept. That is what we can call the legal position. And then it goes on to say, in that sense, so in that respect, it is not ourselves, it's not the IEC, but the laws that would stand as an impediment, right? So the law that I have stated, okay, here's the law that I've stated. In respect of that law, it would impede on that specific candidacy that you are referring to in your question. That is how this paragraph may be interpreted. However, in any respect...
Sorry, my colleague has a question for you. So.
Ms. May,
Yes, ma'am.
surely that candidacy, it's open to interpretation. That's not the only interpretation. And there's also the possible interpretation that that candidacy also means anybody who has been given a sentence. That was so the first part of the quote.
My lady, the question was specifically referring to...
Yes, but we don't know what it's open to interpretation. You're asking us to impose a certain interpretation.
My lady, it is our version that this was in specific reference to Mr. Zuma's candidacy in the sense that, firstly, the question was directly in relation to Mr. Zuma. Secondly, the answer was directly related to Zuma. But even if this court does not accept that it was, the IEC has not furnished this court with any other interpretation. It hasn't furnished this court with any other meaning of the words that are stipulated in the statement. And the IEC does not deny that this statement was made. They simply state that they were stating the legal position, which is not the case. The statement of the legal position ended at the point where she was referring to anyone who has been given a sentence without deferral. And the IEC has accepted that her statement was made in response to a question about Mr. Zuma's eligibility. This is found in paragraph 20 of their answering affidavit. Okay, so for purposes of clarity, I'll just repeat the specific portion of the paragraph 20 that I'm referring to. It states that, it's in the second line of paragraph 20, it states that, moreover, her statement was made in response to a question about Mr. Zuma's eligibility. That
For me,
answers.
it looks like there's a contradiction in that paragraph, because on the one hand, the IEC is saying Ms. Love simply stated the correct legal position. So I read that to, it probably meant the IEC, Ms. Love was simply stating what the law is, right? Legal position, what the law is. And then they go further to say, moreover, her statement was made in response to a question about Mr. Zuma's eligibility. And that states a completely different proposition. It's not just what the law is. The law was applied to this scenario.
Exactly, my lady. And that can also be read in the direct quote itself.
Sorry, Ms. May, but isn't the context important here? Because this is a press briefing, and the question could have been raised to any of the candidates, not specifically Mr. Zuma.
Sorry, my lord, please just repeat your question.
The context
Yes.
doesn't play a role. I'm asking because this was a press briefing. To that effect, a question could have been posed concerning any other candidate other than Mr. Zuma. Then what was the commission supposed to reply?
My lord, on the case that is before us, it was in terms of Mr. Zuma, not just any candidate, and we cannot run away from that. But even then, Commissioner Janet Love had the duty to refrain from making any pronouncement on the issue of his eligibility. But having done so, and having not refuted her statements or corrected the statements that was in the media statement, she ought to have then recused herself from deciding the objections that were entered against the appellants. Alternatively, as I argued earlier, the commission ought to then have requested her to recuse herself in order to ensure impartiality, which we have established is an important factor to be considered in this matter.
Sure.
So would you say that the chronology of events is a consideration in determining whether Ms. Love was biased as you allege? Because I see this press statement is dated 25th January 2024.
Yes, ma'am.
And then it was way before any objection, the period for objections was open.
Yes,
There was
ma'am.
not even an objection.
There was
when
not even
this
an objection that
statement was
existed at
made.
the time.
Yeah.
Yes, my lady, that is absolutely correct. And that is why our submission is that the commission prematurely prejudged the issue of the second appellant's eligibility. It had already stated that in terms of our laws,
Yeah.
this would be an impediment on that, Mr. Zuma's candidacy. And so they prejudged it, and it cannot be that once you have already prejudged an issue or made a certain decision on that issue, that you can arrive at a different outcome when you are now faced with an objection that raises the very same issue.
Okay.
It is on this basis that we say that the decision made by the Commission has been tainted by bias. And the failure of Commissioner Janet Love to then recuse herself from deciding the objections renders the decision a nullity. My Lord, if I may then proceed to the fact that the IEC states that it was a statement made in response to a question. We say that this is irrelevant. The fact is that a statement was made indicating their views on the eligibility of Mr. Zuma. Further than that, as I have stated, they did not refute any of the statements that were published. They did not correct any of the statements that were published. This was done in January. And then in March there's an objection, and they uphold those objections on the very same grounds. That is what brings us today with regards to the issue of bias.
Sure.
In addition, my Lord, the IEC has referred to a test of the reasonable observer of the press briefing would not have come to the conclusion that they either decided or confirmed that Mr. Zuma is not eligible for candidacy in the elections. My Lord, that is not the test. The test is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case. This also indicates to us that the requirement of impartiality is fundamentally important when considering whether there was an apprehension of bias. And
I must warn you now that your 15 minutes time is up, but proceed, but just bear that in mind now, because that was the agreed time.
as it pleases the court,
Sure.
I will try to wrap up my arguments. The last portion that I want to just address this court on with regards to the reasonableness test is that we also do not look at the observer at the press briefing. It is actually looked at from the perspective of the litigants themselves. Alternatively, the reasonableness must be
But
considered.
the test is it not objective? It's an objective test, but why should it depend on the perception of the affected person?
Yes,
Because
my lord, it is an objective test.
That would be subjective.
I agree that it is an objective test. However, in the we have authority, and I'll cite the authority shortly, but we have authority that says that when it comes to considering the reasonable person, we look at the person in the position of the person being judged. My lord, you will find that in paragraph 19 of this case, which is Rasuisui versus the CCMA and others, 2011, 32, ILJ, 2186, and in brackets LC. That is at paragraph 19, my lord, where it states that the reasonableness or the reasonable person is considered in the position of the person being judged. But in the case of SAFU, it further states in paragraph 48 that it is on the part of the litigant itself, which in this case would be the appellants. Lastly, my lord, Judge Pilay's recusal from deciding on the objections further emphasizes the need for Commissioner Janet Love to have done the same. Because in the case of Judge Pillay, in the instance of Judge Pillay, she recused herself on the basis that she was an acting judge at the Constitutional Court at the time that the second appellant's incarceration was being decided. And so she had an indirect interest in that matter. However, with regards to Commissioner Janet Love, she personally made statements. She personally made statements referring to
The very same issue that is now before
the very issue, excuse me. Statements to the very issue that is at the center of these objections. It is for these reasons, those are our submissions, my lord and my ladies, and it is for these reasons that we submit that she, by virtue of having made a statement and not having refuted or correcting it, she ought to have recused herself. Alternatively, the commission ought to have requested her to recuse herself in order to ensure impartiality, and that the failure to do so then renders the decision by the commission a nullity. And on that basis, this court, we humbly request that this court would then set aside the decision made by the IEC in respect of the objections that were raised. My lord, if I may please just check if there's anything further that I need to address. My lord, and just to add, we would like to also refer this court to the English case of Pinochet, in which it was held that it did not matter that there was one decision maker out of the 5 that had their decision tainted by bias. By virtue of the bias of that one decision maker, the entire decision by the entire body was considered a nullity. And it also was accepted that this is not only confined to actual bias, but also to reasonably perceived bias, or what we can also call the reasonable apprehension of bias. My lord and my ladies, I thank you for your indulgence herein, and those are my submissions.
Sorry, the citation, please.
The citation for Pinochet, it's also on item 2 of our bundle
It's in your hands.
of authority. Yes. Those are my submissions. If there isn't any further questions.
I think that we need a comfort break. I know Mr. Ngwai told you are pressed for time, but
yes,
the comfort break is necessary.
No, I accept that. Could I just hand up the...
Sure.
No, that's not so this is... So this is supposed to be the bundle of documents.
The pleadings bundle.
On the pleadings, yes.
Sure.
I think we have 4, or there's a 5th. I'm not sure, my lord, given that we have a special file, whether it should go to the chair or not.
Okay.
But how long will you use the lordship?
Let's take a 15 minutes break. So let's see now. 12:35. So let's come back around about 10 to 1. Okay, the court adjourns until 10 to 1. Okay, can go.